Mr. Hibner, and thank you, Ms. McDaniel and Mr. Fowler, for participating in this oral argument via live streaming Zoom. We will conduct the hearing in the same fashion as if all of us were in the courtroom together. Each side gets 15 minutes, and the appellant has the right to reserve and has reserved some of that time for rebuttal. Unless there are some announcements, we'll ask Mr. Hibner to call the case.
Mr. Appliance LLC versus Appliance Services LLC et al.
You may proceed.
Yes, good afternoon, Your Honors. My name is Chris Fowler. Ben Goldhammer and I represent Appliance Services LLC, Mark Liberte, and Belinda Belerte, and we requested 3 minutes of rebuttal time.
Very good.
In this case, this is an attempt by Mr. Appliance, who I'm going to call the plaintiff for all of the different appliance names we have in the case. Their attempt to enforce.
Excellent idea.
Yeah. So it's plaintiff's attempt to domesticate a foreign judgment that was obtained in Texas. Back in 2017, plaintiff filed a lawsuit against Appliance Services and pursuant to a franchisee agreement, following litigation and multiple attempts to serve the business Appliance Services and Mark Liberte, plaintiff filed a motion for substituted service and was eventually granted an order that allowed service by substitution in the Texas case. Plaintiff eventually filed and obtained a judgment of default in Texas. Noticeably, in the pleadings that are filed in the Texas complaint, you'll notice that there is no certificate of service or proof of service following the initial document that said that Ms. Belinda Liberte was served in November of 2017. Now, after obtaining the judgment, plaintiff has attempted to domesticate this judgment in Williamson County Circuit Court of Tennessee, pursuant to Tennessee Rule of Civil Procedure 3A. Upon filing that lawsuit here in Williamson County, and upon my clients actually being served with that lawsuit, within a matter of several days, an answer was filed within 30 days, and specifically the answer disputed the fact that my clients were not served with the Texas lawsuit and requested a trial on the merits pursuant to Tennessee Rule of Procedure 3A and the comments section. After filing our answer, plaintiffs then moved for summary judgment, which was conducted in front of the trial court in January of 2020. After extensive briefing, the court viewed the evidence that was in front of them, and the evidence being in front of them, the trial record from the Texas court, plaintiff's brief, the memo, and the response. And the response included affidavits which stated that Belinda and Mark Liberte were not, in fact, served with this Texas lawsuit. The court is well aware of the standard for granting motions for summary judgment. Trial court is to look at the evidence in a light that's most favorable to the non-moving party, and only then, if there are no genuine issues of material fact, is summary judgment appropriate. And in this case, recognize that the argument of service is rarely raised, but is an absolute fundamental right to due process, and allows, it requires service to take adverse actions against citizens of the state and the country. And in this case, as I'll explain, the service on Mr. Liberte and the service on Ms. Liberte are insufficient and improper. Ms. Belinda Liberte's service is easier to discuss in that she swears under oath, under penalty of perjury, that she was never served with the Texas lawsuit. Mr. Liberte's argument, understandably, is more technical because the plaintiffs were required to seek substitute service. And as we briefed in our brief, there's three reasons why his service was ineffective. Those three reasons are: number one, the affidavit that's signed by the purported service process server says that he was, quote, advised that Mr. Liberte only comes in once a month, and at best, he only comes in once a month at best. So documents were posted on the front door per order. This violates the requirement of the Texas Rules of Civil Procedure that require the person being served their normal employment, their abode, or where they can reasonably be found to effectuate service. Second reason that—
Was this his place of business?
Your Honor, at the time, this was not his place of business. And what the statement was that the process server understood that he would only be there at most once a month. This is affidavit, trial record, page 147. Second reason is that the order that authorized service left it up to this process server to have discretion as to how he would serve it, which also violates the Texas Rules of Civil Procedure. And finally, the notion that posting the summons and the complaint as indicated on this affidavit 147 is simply not reasonably calculated to serve my client. And there's no question that he was never personally served. The service that was contemplated by the Court of Appeal, the Texas court, is by substitute service. So after obtaining the default judgment, plaintiff seeks to enroll this judgment here and rely simply on the enrollment of that judgment. By filing the answer the way that we did, respectfully, my clients are entitled to a trial on the merits pursuant to the comments of Section 3A of the Tennessee Rules of Civil Procedure, and specifically to attack the validity of the judgment based on insufficient service. Respectfully, with what was before the court, with affidavits as written, and the simple fact we have one declaration on both sides that say either service was or was not proper, and for that reason, there's a genuine issue of material fact, and summary judgment's not proper at this time.
Mr. Fowler, the trial judge found it persuasive that Mr. Liberty claimed he did not utilize the address at where he was allegedly served by public notice. But when the domestication of the judgment summons was served at the very same address, he received notice and filed an answer. The trial judge found that significant, and I find it pretty interesting myself.
Yes, Your Honor. And he did accept service for the Tennessee lawsuit. He's not saying that he doesn't live there now. He's not saying that the service of this case is not proper. He's saying that he was never served with the Texas lawsuit. And
but wasn't he claiming that?
Sorry.
But didn't he claim that was not his address? But it was his address for the first lawsuit, and it was his address after the first judgment.
At the time,
there's no divorce decree in the record. So if you connect the dots.
And Your Honor, candidly, at the time, that was not his address, and now it is, and he's sworn under oath to that effect.
But wasn't it his address before the first lawsuit?
It was not, Your Honor. He was separated from Miss Liberte. I know that that's not part of the record, but that's.
Wasn't it their address before the first lawsuit?
Prior to, yes, Your Honor.
Okay, that's what I was getting at. So it was his address before, and it was his address after, but for some reason it wasn't his address when the first summons was had to be served.
Correct, Your Honor.
Mr. Fowler, what are the facts in dispute?
The facts in dispute are whether or not Ms. Liberte was actually served with the lawsuit, and the facts are in dispute whether Mr. Liberte was properly served, as has been alleged by the plaintiff in this case.
Well, so for the husband, isn't that a legal question as to whether posting meets the requirements of the rules? I mean, what are the factual questions regarding him?
The factual question is whether or not these affidavits as written are sufficient to satisfy the service of process on him. And I agree, Your Honor, that it is a legal question, but based on the language of this affidavit and whether or not serving him at a place where the process server knew he at most would come once a month, whether or not that's reasonably calculated to be sufficient service.
That sounds like a question of law to me, not a question of fact. Am I wrong?
I would agree that it's a factual determination. It's a legal determination as to whether those facts are sufficient to make a legal determination.
So they're not disputed facts. The dispute is over whether those facts constitute sufficient service. And that's a question of law.
Yes. As to Mr. Liberte. And quickly before I run out of time, if I could go to the second part of my argument, which is that the trial court simply erred in granting attorney's fees in this case, pursuant to the American rule, which allows for each party to pay their own attorney's fees, absent some statutory or contractual right, which the trial court recognized are not in this case. There was no basis for it. Secondly, the fact that the trial court, by obtaining the initial final judgment in Texas, any additional claim for attorney's fees would be merged with the final judgment. And as we extensively brief, there should be no attorney's fees as awarded in the enforcement and domestication of this final judgment.
All right. Thank you, Mr. Fowler. We'll hear from you on Ms. McDaniel.
Good afternoon. I'm Erin McDaniel with the firm of Gordon and Reese Scully Manscani on behalf of Mr. Appliance. Thank you for hearing me this afternoon. First, I would like to address the statement of issues that Mr. Appliance proposes in this case. The trial court erred in finding there's no genuine dispute of material fact remaining for trial with respect to the enforcement of the Texas judgment. Whether the trial court erred in ruling the U.S. District Court for the Western District of Texas's November 27, 2018 final judgment is entitled to full faith and credit in Tennessee and shall be enrolled in Tennessee. And whether the trial court abused its discretion in awarding Mr. Appliance reasonable attorney's fees incurred in this matter. By way of background, Mr. Appliance is a Texas LLC and a franchisor of companies that install and repair appliances. Appliance Services of Tennessee is a Tennessee LLC and former Mr. Appliance franchisee. Mark Liberty and Belinda Liberty are a married couple who are the sole members of Appliance Services of Tennessee and guarantors of its debts. Mr. Appliance brought an action against the three defendants in the U.S. District Court for the Western District of Texas back in October of 2017. The Texas District Court entered a final judgment awarding Mr. Appliance approximately $100,000 for trademark infringement damages, breach of contract, and attorney's fees and costs, as well as a permanent injunction enforcing the parties' post-termination non-competition agreement. Mr. Appliance then followed the proper procedures to enforce it in the Circuit Court for Williamson County, Tennessee, pursuant to the Uniform Enforcement of Foreign Judgments Act. Defendant's argument against the foreign judgment being entitled to full faith and credit in the state of Tennessee is based entirely on the conclusory, self-serving declarations of Belinda and Mark Liberty that say they were not served with the underlying Texas lawsuit, despite overwhelming evidence to the contrary. As an initial matter, service of process was determined to be proper by the Texas District Court. A second trial on the merits after the court issued its decision regarding proper service, as well as the substantive claims, is barred under the issue preclusion and res judicata doctrines. On November 29th of 2017, Belinda Liberty was personally served with the Texas complaint and summons at her home address on Gloucester Court in Franklin, Tennessee, which she shares with her husband, Mark Liberty, and which is the same address where she and Mark Liberty were served with the current action to enforce the judgment. I will also note Mark Liberty testified in a deposition in June of this year that it is still his and his wife's current residential address, and that they have been married for over 20 years and not separated or divorced. I will also note that
Did he say they'd never been separated?
I believe he did, Your Honor, yes. He did explain that his company leases an additional apartment or condo in downtown Nashville that he stays at sometimes. But his answer to what his residential address is was the Gloucester Court address in Franklin, Tennessee.
Did you say that was deposition was taken in June of this year?
Yes, sir.
Then that was there is that a post-judgment fact you're relying upon? Because I don't think that's in the record.
Yes, it is not in the record. That is a post-judgment deposition that was taken.
All right. I don't think we can consider that.
Okay. Understood. So after unsuccessful attempts at personal service, several unsuccessful attempts at personal service of Mr. Liberty on March 7th of 2018, pursuant to the Texas District Court's order for substituted service, wherein the court did find that the usual place of business was a business located at Fessler's Parkway in Nashville, Tennessee. Mark Liberty and Appliance Services of Tennessee were served by posted service on the front door of the business located at Fessler's Parkway, as well as the home address on Gloucester Court in Franklin, Tennessee, where Belinda Liberty was personally served. All of the defendants failed to timely respond to the complaint. The Texas District Court issued an order to show cause why the claims against Belinda Liberty shouldn't be dismissed for want of prosecution after she was personally served and no answer had been filed. Mr. Appliance obtained a clerk's entry of default against defendants for failure to plead or otherwise defend in the action, and ultimately filed a motion for entry of default judgment against all of the defendants. On October 5th, 2018, a report and recommendation of the magistrate judge was entered in the Texas District Court recommending the motion for default judgment be granted. The Texas District Court gave the defendants an opportunity to file objections to the report and recommendation, and they were put on notice that a party's failure to file written objections within 14 days would bar that party from de novo review by the District Court and bar the party from appellate review of unobjected to proposed factual findings and legal conclusions. The defendants did not file any written objections, and on October 23rd, 2018, the Texas District Court entered an order adopting the magistrate report and recommendation. Finally, on November 27th of 2018, over a year after the initial complaint was filed and served, the Texas District Court entered an amended judgment, final judgment on plaintiff's motion for default judgment, specifically finding that defendants failed to defend themselves despite receiving proper service of the complaint and summons, and that there is no indication that the defendant's failure to respond is the result of a good faith mistake or excusable neglect, nor is there anything before the court that would oblige the court to set aside the default. The Texas District Court found Mr. Appliance had sufficiently set forth facts entitling it to relief, and default was proper and constitute success on the merits. The default judgment was not rubber stamped. It was the result of a more than year-long proceeding and hearings. Mr. Appliance then followed the proper procedures to register the foreign judgment and enforce it in the circuit court for Williamson County. Notably, on August 7, 2019, Mark Liberty was personally served with the notice of filing and summons for enforcement at the same Gloucester Court address in Franklin, Tennessee, where Belinda Liberty had been personally served with the underlying action. At the same time, he accepted service on behalf of the other two defendants by substituted service at that address. And again, defendant debtors are only disputing the sufficiency of service of the underlying Texas lawsuit at that address and not the instant case. Mr. Appliance then brought a motion for summary judgment at the trial court because there are no issues of material fact remaining for trial. And the Texas court found repeatedly that service was sufficient as to all defendants. Mr. Appliance met its burden of demonstrating the absence of a genuine issue of triable fact. Therefore, the burden shifted to defendants to set forth specific facts showing there is a genuine issue for trial. Of the 37 statements of material facts set forth in Mr. Appliance's motion for summary judgment, defendants dispute only that they were properly served with the underlying action. The Liberties failed to produce any evidence supporting their position other than their own self-serving declarations, which simply deny service and are devoid of any specific facts. They have not alleged or provided proof of a mistake of fact, mistake of identity, or incorrect address as to the service of any of the defendants. Instead, they've implied that two separate process servers have falsified the proofs of service in the underlying Texas action, and there's simply no evidence to demonstrate that. Indeed, the Liberties declarations were characterized by the trial court as a scintilla of evidence or mere denials of Mr. Appliance's contentions. Further, the trial court found no rational trier of fact. The record.
Counsel, other than the affidavits, were there any other evidence or proof presented or offered to support their position?
No, there was not. The full faith and credit clause in Tennessee's Uniform Enforcement of Foreign Judgments Act requires the court to give the judgment from the Texas District Court the same credit, validity, and effect as if it was a judgment from a Tennessee court. A party seeking to prevent the enrollment of a foreign judgment in Tennessee carries a stern and heavy burden. Defendants must show the court any ground upon which enforcement of a judgment of any court of this state would be stayed and vacated in order to stay the enforcement of the foreign judgment, and defendants have not met that burden. Defendants' reliance on Tennessee Rule of Civil Procedure 3A.04 Advisory Commission comments for the proposition that a mere objection to the enrollment of the foreign judgment entitles them to prevent enrollment is misplaced. The comment allows for a trial on the validity of the judgment, and defendants must present cause for such trial, and the Tennessee Rules of Civil Procedure govern that proceeding. Accordingly, Mr. Appliance filed a motion for summary judgment regarding the validity of the foreign judgment pursuant to Tennessee Rule of Civil Procedure 56.04. And in accordance with Rule 56, Mr. Appliance demonstrated there is no genuine issue as to any material fact remaining for trial regarding the validity of the underlying judgment. Mr. Appliance respectfully requests the court uphold the trial court's granting of its motion for summary judgment, as it didn't answer finding no rational trier of fact, considering the record as a whole could conclude the Liberties were improperly served. Finally, the trial court ruled that Mr. Appliance is entitled to an award of attorney's fees on the basis of equity. This court reviews a trial court's decision concerning attorney's fees according to an abuse of discretion standard. A trial court will be found to have abused its discretion only when it applies an incorrect legal standard, reaches a decision that's illogical, bases its decision on a clearly erroneous assessment of the evidence, or employs reasoning that causes an injustice to the complaining party. The decision whether or not to award attorney's fees is within the sound discretion of the trial court.
But doesn't there have to be a statute or contract in order to for Tennessee to award attorney's fees?
Generally there does, but the trial court can also find on the basis of equity that attorney's fees are required to make the party whole, which is what the trial court found in this case. Although Mr. Appliance did argue that there is a contractual base for attorney's fees, but I think the trial court declined to examine whether that existed, since the defendants were disputing whether the contract allowed for attorney's fees. But the franchise agreement did allow for an award of attorney's fees.
Well, that's not what the trial court used to award the attorney fees, right?
Right. The trial court found that on the basis of equity, attorney's fees would be required to make Mr. Appliance whole, because Mr. Appliance simply intended to enroll a foreign judgment. And
Is that the only equity that the court identified? The fact that he attempted to enroll a foreign judgment and wound up with a motion for summary judgment he had to defend against?
yes, Your Honor. Okay, so Mr. Appliance respectfully requests you uphold the trial court's award of attorney's fees, as the trial court did apply the correct legal standard. The trial court also did consider the reasonableness of the fees under Tennessee Supreme Court Rule 8 as well, and did not abuse its discretion with respect to granting the attorney's fees. And that's all I have. If you have any more questions.
Well, refresh my memory, please. Did the trial court cite any case law for equity being a basis for awarding attorney's fees?
Yes, Your Honor, they did. He did cite case law.
All right. Anything further, Ms. McDaniel?
No, I don't have anything further.
All right. Thank you. Mr. Fowler, your rebuttal. Be sure to unmute.
Thank you. Sorry. On the issue of attorney's fees and the case law that was cited by the trial court said that the basis was for equity alone, and the case law that was cited was a case of Gonsuski versus Gonsuski, which is a divorce case that statutorily allowed for attorney's fees to the prevailing party. There is no case cited in the trial court's order that allows for attorney's fees to be recovered on the sole basis of equity. As far as the enrollment of this foreign judgment, Rule 3A provides that if a judgment debtor does dispute the notice of filing foreign judgment, then the Tennessee's Uniform Enforcement of Foreign Judgments Act entitles the debtor to a trial on the merits concerning the underlying validity of the judgment. And the Tennessee Rules of Procedure govern the trial on the merits on that answer and response. It's exactly what was done in the answer in this case. When it says a trial on the merits of the underlying validity, that's the words of the statute in the comments. Whether or not trial court believed Mr. and Mrs. Liberte, whether they're credible or not, is a question of fact that should not be disposed of in a motion for summary judgment. And for all those reasons, we're asking that the granting of the motion for summary judgment be set aside and that the award of attorney's fees in this case be vacated. And I'm happy to answer any questions you might have.
All right. Thank you, Mr. Fowler and Ms. McDaniel, for your arguments. We will take your case under advisement. Mr. Hivner.
This honorable court is now in recess until 3 p.m.
Thank you.
Thank you all.
Thank you.